Hello and welcome to One and All. My name is Lakshay and I'm an intern at LEXIS and Co. I'm a third year law student at New Law College, Pune, and the topic for the day is importance of cybercrimes in India. Today's world is ruled by technology, and whether we like to admit it or not, we all are slowly falling in terms with this technology. With everything either being digitalized or being available on the internet, it's only fair to have some new guidelines and set of rules to safeguard an experience on the technology-based platforms. This is the place where cyber laws come into play, and today's article will talk extensively about how cyber laws are important in India. Cyberspace is the computer-generated world of the internet, and the laws that govern it are known as cyber laws. And all users of this space are subject to these laws, because it has a form of global jurisdiction. Cyber law is a branch of law that deals with legal issues arising from the usage of interconnected information technology in a nutshell. Cyber law governs computers and the internet. The Information Technology Act of 2000, the National Cyber Security Policy of 2013, and any other Indian statute does not specify cybercrime. As a result, cybercrime might be defined as a combination of crime and computer. In other words, a cybercrime is defined as any infraction or crime involving the use of a computer. Even a minor crime like theft or pickpocketing can be classified as cybercrime if the basic data or help to the crime is a computer or information saved on computer used or misused by the fraudster. A computer, network, data, information, and all other necessary ingredients that make up a cybercrime are defined by the Information Technology Act. Cyber law has the following crimes under its purview. They are mentioned as cybercrimes: electronic and digital signatures, intellectual property, data protection, privacy. Computers, network, software, data storage services such as hard disk, USB disk, and so on. The internet, websites, emails, and even electronic gadgets such as the cell phone, ATM machines, and so on are all the part of cyberspace. Cybercrimes can further be categorized into broader topics like cybercrime against person, which involves stalking, impersonation, harassment with the computer. Cybercrime against property, unauthorized computer trespassing, computer vandalism, siphoning of funds from financial organizations, stealing information and data, copyrights. Cybercrime against government, hacking of government websites, cyber extortion, cyber terrorism. The Information Technology Act 2000, which is also known as the ID Act, which involves into effect on October 17, 2000, contains cyber legislation in India. The Act's principal goal is to give electronic trade legal status and make it easier to file electronic records with the government. Even with the most compassionate and liberal interpretation, India's existing laws could not read in the light of the emergency cyberspace to embrace all aspects of relating to the various internet activities. In fact, actual experience of wisdom, judgment that interpreting existing laws in the context of evolving cyberspace without establishing new cyber laws will not be without substantial hazards and difficulties. As a result, relevant cyber laws must be enacted. Cyberspace activities had no legal authority or authorization under any of the existing laws. A huge majority of users, for example, use the internet for email. Email is still not considered legal in our country. There is no law in the country that grants email legal status and consequence. In the lack of formal statute provided by the parliament, courts and judges have been hesitant to provide judicial legitimacy of the legality of email. As a result, a need for cyber law has evolved. To summarize, while a crime-free society is ideal and merely a dream, there should be continuing effort to keep criminalities at a minimum by the application of rules. Crime based on electronic law breaking is expected to increase, especially a society that is becoming increasingly reliant on technology, and lawmakers will have to go the extra mile to keep imposters at bay. As a result, rulers and legislation should make strenuous efforts to ensure that technology develops in a healthy manner and is employed for legal and ethical economic growth rather than criminal activity. It should be the responsibility for three stakeholders, namely rulers, regulators, and legislators and agents, users, internet or network service providers, banks, and other incentives to take care of the information security by playing their respective roles within the permitted limits and ensuring compliance with law of the land. That was all for the topic. Have a great day.